Good morning, everyone, and welcome to our opening panel here at CPDP 2023. It's a great honor to be here. My name is Zarsky. I've been part of CPDP for many years, currently the Dean of University of Haifa Law School and one of the members of the Haifa Law and Tech Center. So the purpose of this panel is to reflect on the GDPR's many faces and to examine different ways that GDPR tries to achieve various objectives, and through that to engage in some thinking about the development of the GDPR, its jurisprudence, and where it might be leading us. And I want to give you a quick example of the problem or the fact that the GDPR itself has several layers. It brings together several forms of governance, and it also tries to achieve at the same time several objectives. So in a recent paper I wrote about breach notification, I pointed out that the GDPR strives, when attending to the issue of breach notification, to enhance mitigation, to lead to some form of retribution to victims, and also to deter firms from having low levels of security, and at the same time to enhance flows of information between relevant parties. It's very difficult to achieve all these objectives at the same time, and at times these objectives contradict. So at times, regarding this issue and many others, we get the sense that the GDPR really needs to decide what it wants to do when it grows up. To help us in our inquiry, I'm turning to our panel. We have an excellent panel. We'll start with Dr. Gabriela Zanfir Fortuna, and she's a Vice President of Global Privacy at the Future of Privacy Forum, which is a global nonprofit based in Washington, D.C. And I remember that in 2014, Gabriela won the inaugural Junior Scholar Award, and she kept on from there doing excellent work with the European Data Protection Supervisor in Brussels, and then moved from there to the US. So Gabriela is going to start us off thinking of various objectives within the GDPR, and then I'll move on to introducing the rest of the speakers once we get to them. Gabriela, please.
Well, good morning, everyone, and thank you so much for joining us at this first panel, the first day after the opening night, and this means that you care a lot about these issues, so thank you for being here. Thank you very much for organizing this conversation. I wanted to start off with a couple of ideas, just some reflections about the GDPR after 5 years. When we were preparing for the panel, one of the things I wanted to focus on was the governance of the GDPR and its enforcement. But before I go to that point, I wanted to first reflect on the fact that, the GDPR is just the current expression of data protection law in Europe. And one thing that we need to think about whenever we talk about the GDPR is that data protection law is much older than the GDPR, but also much larger, broader than the GDPR here in the European Union, because it has that fundamental rights dimension where regardless of how we decide to change the GDPR in the future, who knows, maybe we will reopen it or not. There's clearly no appetite to reopening it, but it will always need to reflect whatever the Secondary Law Act will have. It will need to reflect what we have in Article 8 of the EU Charter of Fundamental Rights, and we have a lot of quite detailed things mentioned there. And we also have an Article 16 in the TFEU that also has some very specific issues mentioned on data protection law, giving the European Union the competence to adopt legislation there. I'm bringing this up because Article 8 Charter and Article 16 TFU, both of them recognize that you need to have an independent supervisory authority that is enforcing the rules on the processing of personal data. And I think that's a very interesting component of a fundamental right to data protection that might have some consequences as the GDPR is being implemented and as we have this new EU data strategy package that actually has some rules that impact the protection of personal data, but doesn't have the independent supervisory authorities necessarily enforcing those rules. So I think that's an interesting wrinkle there. Now, if we are to reflect on how the governance of the GDPR has been working after 5 years, and as we are discussing about the many layers of the GDPR, another thing that I think we don't reflect enough upon is that the GDPR deals with the most, like from the most minutiae, random things, conflicts between neighbors that install CCTV, like a very private relationship. And we have decisions from data protection authorities that actually look into that. And you know, sometimes the household exemptions apply, sometimes it doesn't in the private relationship conflict that might appear. So from those very small things up until some of the most impactful developments in society today, in the digital economy, in the digital society. We have decisions that look at facial recognition, at how algorithms are functioning, that look at big tech, at social media, and their impact on democracies and societies. So it's a very, very difficult thing to scale. I honestly don't envy the task that data protection authorities need to do, or courts or judges. I mean, it literally touches upon many, many issues there. Now, in terms of how governance has been going in the past 5 years, it's been going. We have many cases that are quite significant, and actually my colleagues and I at the Future of Privacy Forum, we've developed a passion into looking in case law of the GDPR from data protection authorities and courts in very specific, on very specific articles. With the most recent one, we looked into Article 25 of the GDPR, data protection by design and by default, and we published a report that summarizes 92 cases. And clearly, you know, there is enforcement, and there is also enforcement of some of these new complex, nuanced provisions, like Article 25. On another hand, at some other level, there is at least the perception that things have not been working out as intended at the very beginning. And I can't help shake off the feeling that this is the case when I'm looking again at the data strategy package of the EU right now, and we're seeing the Digital Service Act, the Digital Markets Act, for example, intervening in some of the issues that the GDPR was meant to tackle, and giving enforcement powers to the European Commission, centralizing the enforcement. I can't help shake off the feeling that that is maybe perhaps a reaction to how the effectiveness of the GDPR enforcement has been perceived, at least by the Commission. So I'll just leave this thoughts here at the beginning as we kick off the conversation. Thank you.
Thank you very much, Gabriela. So now we'll move to hear from Amit Ashkenazi. And Amit, No, I'm sorry. Now we'll move to hear from Raphaël. And Dr. Raphaël Gellert, he's an assistant professor in ICT and private law at Radboud University. He's a member of Radboud's Business Law Institute. And he's also affiliated with the research group, a very strong research group here in Brussels on LSTS at the Free University VOB. And maybe most relevant and important for today, he's an author of an excellent book on risk-based approach to data protection, Oxford University Press 2020. And Raphaël will, within our broader theme of trying to figure out what the GDPR is and what it does, he will implement his thoughts about regulation that deals with risk to the context of data protection and GDPR and see if indeed the GDPR is initially striving to do so and if it's doing so successfully. He'll provide us some background and also some implementation. Raphaël, please.
Yeah, thanks very much, Tal. I think I have a few slides that should be coming up, but if they're not there, yeah. So indeed, what I want to do today very quickly is, even though we are not now at the GDPR at 5, it's actually go back in time and go back to the sort of roots and the underpinnings of the risk-based approach. This is why I talk about the ideological dimension of the risk-based approach. And what I'd like to do is I found this quote, which I think is a very nice quote by Julia Black, which is a big name in the field of regulation theory. And she says, so in this regulatory utopia, regulation is targeted and focused and preferably harmonized across jurisdictions. Regulated firms are given the flexibility they need to get on with running their businesses, and consequently regulatory outcomes are achieved with no undue costs to businesses. And I thought that was a really interesting quote because, I mean, you could think that it comes really from the, you could call it the official propaganda from the European Commission when they were touting the GDPR back in 2010 and, talking about risk-based approach and accountability principle and how everything would be fantastic. But actually, it comes from a description of financial regulation in the UK. And so I thought that was quite interesting because it really sort of touches the core of the sort of, what I call here the ideology or the ideas that underpin this idea of risk-based approach that we find in the GDPR. The basic idea would be that basically we have a better implementation of the data protection and the GDPR rules because there is now a collaboration between regulators and regulatees, so those to whom the regulation applies. And this takes place with a delegation of power and competences to these actors. And so that's really the base of the bargain that underpins the accountability principle and the risk-based approach. Is really that each side will fulfill its sides of the bargain, and this will lead to this sort of perfect model of regulation and a great collaboration between actors without undue costs. But of course, things are not so simple, and this is what I'm trying to get to in these few slides. And this is the fact that there's a sort of a utopia, or you can also call it an ideological dimension behind this idea of making regulation more efficient. And of course, what is this then? This sort of ideology. So here I talk about sort of neoliberal regulatory bargain. So these are kind of big words, but you'll see they kind of make sense. And the idea basically is that the collaboration in the GDPR and in the risk-based approach is made possible only insofar as regulatees, so mostly data controllers, are trustworthy and made responsible. And here, what is interesting is that this concept of responsibility is actually is a twofold responsibility, because on the one hand we see that data controllers have a sort of internal responsibility, so they need to make sure that they achieve their own goals, their own business goals or state goals or whatever they are. And this is where it becomes interesting. There's also a second layer of this responsibility dimension, and this is the external responsibility, and this is precisely the sort of commitment to regulatory goals, or the idea that while you achieve your business goals, you can also be responsible in a social way, and in our case, in a regulatory way. Yeah. And so the idea, of course, is, does this lead to a more efficient regulation? Well, it can lead to a more efficient regulation, but there's a but again, and this is, again, a sort of ideological dimension. So here, another quote. And so this leads basically to a sort of what we call a neoliberal regulatory ideal, whereby the traditional problem of compliance no longer exists because regulatory and business goals are perfectly aligned. So it's really the idea that, yeah, you can have your cake and eat it. You can pursue all your goals as a data controller, and in doing so, well, you also happen to be in perfect compliance with the GDPR. And I think that's really sort of the assumption behind the regulation model in the GDPR and the collaboration between controllers, data controllers, and regulators. And so very quickly, so now I'm just talking in very general terms, but how do we unpack this more concretely? Well, you can see it at various levels. So for instance, you can see it at the level of risk, and the concept of risk that is embodied in the GDPR. And so very quickly, for instance, there has been some criticism on the fact that, sometimes the concept of risk is a sort of risk that is mostly focused on the process rather than on the substance. So, many times or in various cases, you see data controllers that focus more on the process. For instance, so I don't know, do you have sufficient measures for personal training, for periodical review of your risk management process? Yes, and if you have this, that means that the risks are adequately managed. But these are very, of course, process-oriented measures that says nothing about what you actually do with personal data. So that's, for instance, one example. And the other key point here is that the concept of risk with which data controllers can work is kind of recoded as embodying both the organizational goals and the regulatory goals. And of course, this can lead to some tension between these two goals, because here the idea is that, these goals are perfectly aligned, but of course, that's not always the case. And yeah, what I want to say also is that this double support, this double dimension of responsibility was also, for instance, to be seen during the adoption process of the GDPR, where you had a lot of, for instance, civil society actors that would, for instance, that did support the adoption of tools, risk management tools, such as DPIAs. DPIA is also very important with regards to the way that AI regulates, AI and other emerging technologies. But at the same time, you also had the support for these very same tools by, big players and big corporations. So just a way to illustrate how there's what I call a sort of fundamental ambiguity, actually, that underpins the risk-based approach. And it's really this sort of idea of natural compliance that, everything is the best in the best of possible worlds, that, we can do great data processing and be in full compliance with the GDPR. But of course, the question is, to what extent this happens in the reality, and where are the actual tensions? And so that's why it leads me to the question of, how much utopia can we have, or how much trust can we have, and on the other hand, how much verification or control or enforcement do we need? So yeah, and I just had one more slide, but I don't know how I'm doing with time. Okay, so then very quickly, just to illustrate these tensions, maybe in the GDPR, I think a good example is Article 35, so about DPIAs, and I think it's a good example because it really shows the sort of tension in terms of trust and control that sort of underpins the GDPR. Because, for instance, if you look at the way that a data controller needs to define what is a high risk that would lead to a DPIA, you see that there isn't much trust, actually. This is a very much controlled a sort of a regulatory setting, because first a data controller needs to look at Article 35 that already gives some examples of what a high risk is. Then you need to look at the national lists by the data protection authorities. And on top of that, you always have in a residual way, the 9 high risk criteria in the EDPP guidelines. So here you see that the discretion of the data controller is very much curbed. But on the other hand, you see that there's also a lot of discretion if you turn to issues of transparency with DPIAs, because in the GDPR, there are absolutely no provision or no obligations to make DPIAs transparent, nothing at all. And also in terms of the review of the DPIA process, because of course the risks change all the time. So now the GDPR gives a lot of leeways to data controllers, just talks about where this is necessary, whereas in previous draft there was a concrete obligation to do this every 3 years. So a lot of discretion. And also Article 36 on prior consultation, when a data controller thinks that the risks are insufficiently managed, here it's full discretion. And of course, this can be very risky because we're talking about, data processing operations that are by definition risky. Otherwise, we wouldn't be talking about Article 36. So yeah, these two aspects with regards to DPIA, I think really kind of encapsulate the sort of tension that underpinned the risk-based approach in the GDPR. And yeah, leave it at that.
Thank you so much, Raphaël, and we'll get back to you in a moment. So what we're slowly unfolding here is that while many of us see GDPR as an overall clear, aggressive form of regulation, Raphaël is showing us how within it are embedded many other forms of regulation, some of them perhaps relying on gentle nudges, which the regulator will generate to the various firms that should take various actions to balance risks. Okay, well, meantime, calibrating our presentations here. But now we'll move to show this issue with greater detail to Amit Ashkenazi, who is a law and technology expert specializing in cybersecurity, data protection, and AI. Amit teaches law and technology courses in Israel's leading university and is writing a thesis on data protection and governance. And Amit comes to us with extensive governmental experience. He was a consultant in the Israeli Ministry of Science and Trade while writing a form of AI regulation. And between 2014 and 2022, Amit was head of the legal department, Israel's cyber directorate in Prime Minister's office. And before that, from 2008 to 2013, head of legal department in Israel's DPA. Were we able to get the presentation?
I hope so.
Okay, so Amit will move us forward to show how some of these ideas are incorporated, showing us, again, various facets of GDPR and how we're trying to bring them together. Please.
Thank you. So it's really exciting to be here and tell you the story, some of it very personal, as you can imagine, about the hopes, dreams, wishes in designing data protection regulation. So very basically, does this, yeah. Okay, so technology is not with us. Okay, so thank you. Very basically, what we aim to do, is look at these accepted principles that have been part of data protection law, as mentioned. And what the GDPR added, and this is where tensions are growing, right, is two main issues in my reading. This move to accountability, and a lot of time you see the word risk, which wasn't there in the previous legal regime, and the important move to enforcement. So these are two things, and the accountability part is green and the enforcement part is in red as part of this narrative that Professor Gellert described about utopia of having the right incentives in place. But we have to remember that this is a unique regulatory regime. We'll touch upon that in a minute, because it aims to do something which other regulatory regimes are less geared to, it has the ambitious goal of prevention of risk to fundamental rights and freedoms. So this is regulation stemming from a specific area of law and economics, aiming to protect a fundamental right. And so, okay. And so, next slide, please. Thank you. Next slide. Okay, so the problem here, and this is a high-level abstraction of it, is this problem of law on the books, law on the ground, and what is known in technology regulation as the pacing problem, right? So we are here, I'm looking at this from a point of view of a company wanting to do the right thing into this narrative. And actually, the way data protection regulates use of technology is at the second stage, because data protection, as we know, unlike cybersecurity developments, unlike artificial intelligence development, doesn't regulate technology at source. So a company now buys into technology in order to be competitive and is having relationships with its citizens, consumers, whoever is using the technology. And it probably will take some time before legislator, regulator, or court says what the right normative solution is. Now, this is an important part to promote compliance, because the people that want to comply need to understand what the law says. And then after they know what the law says, we have second-order issues of making sure that they deploy this responsibly within their organizations and that they indeed internalize, if you like, these types of views. And as mentioned, the GDPR puts a lot of pressure on interpretation, both on the company and on the regulatory institution, the regulator, because he is the de facto bridge between these fundamental principles and the ground. And so in order to explore this area, I will do two things. The first thing is just to realize how diverse the data protection jurisprudence landscape is. And the second is to focus on risk management, and risk management from a cybersecurity perspective. So some of the discussion about risk management have looked at where risk management is deployed in other fields of regulation. I think cybersecurity can teach us a lot. Next slide, please. So basically, when we unpack the GDPR, obviously it's a data protection law, but we can see that the legislator has been very fruitful in importing to the GDPR different fields of law from a legal point of view, requiring the legal interpreter, be it the regulator or the court or the in-house legal counsel, to buy into these different legal fields and see if the importation is smooth, and how do these different fields of law, with different aims and different measures, integrate into the way they work in the GDPR. And as the way this question is posed, I'll try to show this when we talk about risk management. These things are not always completely aligned. So when we think about moving forward with the GDPR, we need to have some sort, if you like, a jurisprudence in developing the different areas of the GDPR according to the different context or legal fields that they were borrowed from, arguably. And this is another heavy burden of the GDPR as a part of the data protection family, which is one of the, let's say, older sons in the law and technology ICT discussion as well. So it's not surprising that so much burden has been put on this legal regime, because it has been there to deal with technological developments since the 60s, the 70s, and technology has evolved in a very, I would say, large and wide-spanning way. So the first reflection here is in a positive sort of jurisprudential inquiry into how we can improve our understanding of what the laws are in these areas. The areas in bold are areas that are more relevant to the modalities of regulation. I'm not sure we'll have time to continue there, but should I continue directly to the cybersecurity part? So next slide, please. So just a brief introduction to talk about cybersecurity and why cybersecurity is so important as a tool set and as a developing legal regime for our reflections on GDPR risk management. Next slide, please. So just that we're aligned, this is, I guess, in this audience, we don't need to say this too clearly, but it's quite clear that there are two distinct fields. One talks about cybersecurity, and this is the way we manage risk to our data and processes from technology. So looking at what bad things can happen because of reliance on technology. And then we have data protection or privacy risk. This, of course, an American conception. I beg your pardon for using this NIST abstraction, which talks about how we want to tame technology to protect those fundamental rights and fundamental principles, which are not the security stricto sensu. And then we have a connection in the GDPR, for instance, Article 32, which talks about making this cybersecurity technological risk management also a legal risk management. And we've seen this developing in law and regulation. NIS 1, NIS 2 in the EU and other countries legalize this discipline. Next slide, please. It's important to note, and remember that from here on, I'm describing cybersecurity, but I want you to reflect on the differences between managing cybersecurity risks and data protection risks, and what we can learn about the challenges for governance in each of these areas. So the way the GDPR does this exercise, it has a section in the law. It's quite general. And the implementation in practice is done through the technological community, the expert community that understands technology and understands the management of these risks. So we have a division of labor, if you like, between experts and the law is, of course, aimed at internalizing risks. So this is talking to the compliance in the companies, etc. So these are the way forward. And what are the challenges that this discipline, cybersecurity, is facing today? Next slide, please. The challenge is that when we analyze cybersecurity risks, we need to analyze from a company's point of view and, of course, from outside, two types of variables in this equation. One variable is, as you can see on the left, is the exposure and the risk that is created because of the use of technology. And this depends on how much we rely on technology. And this leads us to the second part, which is what type of bad things, what type of harms, what type of impacts can happen if we rely on technology or if technology is misused. And from a company's point of view, this can apply to personally identifiable information, intellectual property, critical processes, accounting. And to connect to something Professor Gellert said before, it can also connect to regulatory or contractual exposure. And here, when we think about some more abstract exposures, such as risk to fundamental rights, it could be rational for a company to bring this down to earth through conceptualizing through its regulatory or legal exposure, right? Because what is a risk to a fundamental right? Probably what the DPA has found, that will be legitimate. But again, where does this go to our noble aspirations? I was part of those aspiring when I was in the DPA, that companies will be innovative with risk management and think about new solutions, not wait for cues from the DPAs. So this is the way cybersecurity risk management is done, and it's quite a difficult task. It requires something that we also know from law, and this is looking at chains of causation between things that can happen and go wrong. Next slide, please. So just to illustrate this, this is a great manual by the Canadian Center for Cybersecurity. Next slide. And it talks about the way that, can you just click through the, okay, thank you. It talks about the way ransomware attacks happen. Now, this is a causality chain developed by the government, so think about rules for DPAs, about how technological attacks happen. And if you read this manual, you'll see that at the end, each one of these stages has also a mitigation strategy suggested by the Canadian Center for Cybersecurity. So here the cybersecurity agency or regulator has developed these causal chains of events that lead to harms, and then talked about mitigation strategies. And why have they done that? Next slide, please. Another, I just want to move forward. Thank you. They've done this because when we look at the issue from cybersecurity, this is a very high-level abstraction of the causality chains of a cybersecurity event. I don't have time to go into this great article, but you can see from the circles and the lines that this is a complex chain of events. And this is something that organizations have objective issues in dealing with. So we can see what an innovative, again, sorry for using the American example, innovative risk-taking regulator has done. Next slide, please. The cybersecurity agency in the US has actually filled in some of the blanks in the cybersecurity formula such that organizations can prioritize their investments according to the higher, riskier chains of events leading to damage. So the question coming back to our, next slide, please. Coming back to our panel is dealing with the risk from information systems when you are aiming at something concrete such as a ransomware attack, everyone understands that's a bad thing, is very difficult. And here we see more expert knowledge coming from government to explain these types of chain of events and how to stop them. And this helps organizations comply. The question is, how are these things, can they teach us about what we need to do to reach effective data protection regulation?
Thank you very much, Amit. And so slowly we're parsing away here, trying to figure out what are the signals that the GDPR sends to regulators, to firms directly, and to firms indirectly through the impact on the regulators. And again, we see the fact that perhaps the GDPR is speaking in a few voices, in a few tones, in a risk-based voice, in a regulatory enforcement voice. It's leading to perhaps mixed messages and unclarity. And at the end of a chain, we have clients. For that, we're turning to Sam Choi, who has joined us here from the Brussels office of Covington. Sam has extensive experience advising clients on data protection issues. And when we say clients, it's both firms, it's also governments. Sam has been working with the government of Rwanda on development and implementation of their new data protection law, and I'm sure hopefully share with us some ideas on those issues. She's also working on other tech-related matters such as AI, online platforms, digital health products, and autonomous vehicles. So Sam, maybe you could educate us a bit on how this looks on the other side of a mirror to your clients of various firms.
Yep, thanks very much. Hi, everybody. I'm Sam from the Brussels office of Covington, as Tal introduced. I want to share some thoughts about the practitioner's perspective about what my co-panelists have been talking about. So firstly, on the risk-based approach, one of the things that I notice in my practice is that every company seems to have a very different approach to managing privacy risk. And that is reflected in the corporate structure of the company and how they set up their data protection functions. It's also reflected in the significance that the business gives to the advice given by their legal or compliance or privacy teams. It's also reflected in the final decisions that are made at the end of, say, a data protection impact assessment or a legitimate interest assessment. And one thing that I noticed that's interesting is that different sectors of my client base have many different approaches. So for example, in the financial services sector, I see a much more risk-averse approach to privacy compliance, where they make a lot of effort to comply and to document and to make sure they have the right processes in place. Contrast that with, say, the tech sector, where they're much more forward-leaning in terms of risk. And you have the pharmaceutical sector, who tend to have a risk-adverse approach in terms of making sure they want to do the right thing, but sometimes don't have the right resources technologically or within their legal or compliance teams to do all of the things that are required to button all of the holes in the GDPR that they require. And that, I think, is a very interesting takeaway. And some of that, I think, is driven by the consumers, the customers. And the customers could be consumers as in individual consumers of specific products. It may also be business customers. So some companies operate on a completely B2B basis, and that gives a different risk profile. And when we were talking about how to bridge the gap between what the regulators expect and what is business imperative, Where I see the biggest gap is where the consumer, whether that be the individual consumer or the business consumer, has an interest or not so much interest in protecting their privacy when they use the service. So if the service is very convenient for users and the service requires people to give up some of their personal data to the company so that they can process it, then the company feels that they can stretch the flexible concepts in the GDPR, like legitimate interest or contractual necessity, to provide them the service while processing their personal data, and they take a calibrated approach to risk in that respect. But if the service is less data dependent, or if the customer is a business customer that feels very strongly about the fact that their data that's stored by the service provider must be protected, then they will impose much stricter requirements in the contracts, in the technical and organizational measures that are recorded in the DPIAs and the data processing agreements as well. So I think the different types of organizations and different services have been coming up with very different ways of structuring their service. One thing I want to touch upon is that the risk-based approach also comes through on the specific obligations as well. So for example, Article 28 of the GDPR that requires data processing agreements, by now, over the last 5 years, lots of standard templates have been going around, and companies have kind of a song and dance that they do to negotiate parts of it, but people know what they're getting into when they do that. So compliance with that is pretty standardized across the industries, I must say, by now. But you have still outstanding issues like legitimate interest assessments or the level of transparency. How to provide transparency to children who may not be able to understand lengthy privacy notices written for adults. How to deal with issues like getting verifiable parental consent. Those more woolly issues companies are struggling with, and different companies take different levels of compliance, some investing a lot of money and resources into trying to get it right, others saying we'll follow the market in terms of what's happening and wanting to learn more about benchmarking experiences. And that ties into the enforcement issue that Gabriela was mentioning. What the regulators are enforcing and the topics that they're focusing on for their enforcement really drives the agenda of the companies when they allocate their privacy budgets or when they allocate their resources to privacy compliance. So over the last 5 years, we've seen a lot of enforcement on issues like data breaches, on cookies and direct marketing rules, a little bit of enforcement on transparency connected also to cookies and direct marketing to some degree. We've seen some enforcement in the data transfers area. However, we have not yet seen a massive level of jurisprudence or case law developing on issues like legitimate interest, for example, or on data subject rights, on the exemptions that apply and how to balance that. And those jurisprudence and case law are developing, and I can see that in my practice. We have investigations on those topics that we work on. But because those are not yet publicly available and there doesn't yet seem to be a consensus on those issues among regulators, companies really struggle with how can we do this lawfully. And I want to end my practitioner's view with one last thing is research and development and innovation. Research and development and innovation is a very key top-of-mind theme for lots of companies in this sector. They want to use the data that they're getting as part of their service when they work with their customers, including like marketing data, it could be HR data, it could be data that's generated from IoT devices. They want to use the data to try to improve their service, come up with new services, to do research. They want to share it with academia in some cases, especially in the pharmaceutical sectors. They want access to real-world evidence data. And so the research exemption is one, again, where there is very diverse ways of approaching the research exemptions in the GDPR and how that applies to, say, purpose limitation principle, how Article 89 works interacting with Article 9 in the GDPR for sensitive data. So those issues we're grappling with every day. And from a practitioner's perspective, more clarity on those issues would be helpful for companies. But I always tell companies, be careful what you wish for, because you might say you want guidance, but if the guidance is not what you want, then that's a different problem altogether. Final remarks about my experience with Rwanda. I've been working with the government of Rwanda for about 3 years now on their new data protection law. And it's been a very educational and interesting experience for me, because I'm a very pragmatic person. I'm like, let's look at the law. What do you have to do? Let's get it done. But from this legislators and regulators' perspective, I've been kind of putting my feet in the shoes of, say, what Amit has been doing, being like, what should we aspire to? And what is it that this economy needs in terms of data protection law? And what it needs is not really a formalistic law that will impose a lot of heavy compliance burdens on companies. What it needs is providing the foundation for building trust among the consumers in digital products so that the economy can go into a digital society. We also needed to think about priorities like making sure that the country could leverage the resources and services available by global service providers, while at the same time making sure that the government and the regulator knows what's happening to the data of the citizens of Rwanda. So balancing those things out in the Rwanda law was an important priority, and I'm continuing to help the regulator formulate their thoughts about this topic. Thanks very much.
Thank you, Sam, and especially thank you for those final reflections. We've all read and some have written about the Brussels effect. But when we write about the Brussels effect, we assume that exporting the notions of the GDPR means one thing. Seeing that the GDPR has so many facets, we see that the Brussels effect means incorporating different ideas in different contexts, and this was an extremely elucidating example. We're going to close our round of speakers, turning back to Raphaël and to provide us with a few more thoughts and implementations on his innovative understanding of regulation and risk. Please, Raphaël.
Yeah, thanks very much, Tal. And so here I need to get back to the slides, to my set of slides. Otherwise, I can do without. Let's see. All right, so otherwise I'll just get started and we'll see if the slides catch up. So what I want to do to say very quickly is, I want to talk about the fact, about the limits of the GDPR and the limits of the concept of regulation itself, because this is a bit also the conversation that we're having here. So, what type of regulation is the best? What goals do need to be implemented, and this and that. So, very quickly, what we've seen with the GDPR and the risk-based approach is that, of course, we can qualify it certainly, I would say, as an honest attempt to address many of the issues that were plaguing the data protection directive, but as has now already been made clear with Amit and Sam. So, of course, in trying to address these issues, the risk-based approach has already created some new problems of its own, of course. And we've talked about, for instance, the concept of risk and the risk to the fundamental rights. That's really complicated. We also talked about the issue of how resource intensive it is, both in terms, for the regulators to come up with templates, also with data controls who don't have the resources to comply with the GDPR and Chapter 4. We've also talked about the relationship between data controllers and regulators. So what is the optimal dialogue? How much guidance do you want? How much do you need? And so, Sam, you mentioned that companies careful what you wish for, but that also the same goes for regulators, of course, because then they also can be trapped in allowing certain types of practices that they might regret at some later point. And yeah, another point, of course, is what I already mentioned before, the managerialization of data protection, or what I also call a new type of box ticking. So in the end, it's just another type of paper trail that doesn't really contribute to real data protection on the ground. So these are just some of the caveats and some of the problems that the risk-based approach creates while trying to address the issues of the previous data protection directive. And the fact that, you always create new problems, that leads also to the limits of risk and regulation more generally. And so we see that the risk management approach, it can work, but does not always work, and it works, in a limited way. Yeah, and that really leads to this question: is regulation an intrinsically limited concept? Because that's, like I mentioned before, that's what we're talking about here. What is sort of the best model? How can we have a regulatory model that works best for everyone? And here I want to go back to this scholar, Julia Black, who mentions the inherent ungovernability of social actors, systems, and networks. And I found also this a very insightful quote, because it really points to the sort of inherent complexity and difficulty of regulatory activity, respective of the regulatory model. So in other words, there's just no perfect regulation model that would perfectly deliver on everything that we wish for. And going back also to my initial presentation, that also means that, we're sort of back to utopia, and that maybe that's sort of the red line here when we are trying to come up with the best regulation model. So I think these were my additional words.
Thank you. So we have now 10 minutes or so before we move to the Q&A to have some questions and discussions between the panelists. And I'm going to pass the mic to Gabriela in a moment for 3 short tasks. I'll be asking you one general question, one specific question, and then I'm going to ask you to, if you would want, ask a question to one of the fellow panelists. And my first general question would be, we spoke about a lot of problems here and facets of the GDPR, but looking back and based on your work and scholarship, what do you see to be the main achievements of the GDPR in promoting accountability? And out of them, what can we take to other jurisdictions? If you would want to add, where would they be more cautious, learning from perhaps mistakes in the GDPR process?
Thank you so much for the question. In terms of main achievements, I think everybody underestimated back in the day when the Brussels bubble was very busy working on the GDPR during those years before it was adopted, in between 2012, 2016. Everybody underestimated the kind of impact it will have outside of the European Union in many aspects. One of them being the blatant direct influence of other jurisdictions adopting very similar type of laws or updating their pre-existing older privacy data protection laws, being inspired by some of the new concepts in the GDPR, like data portability, for example, which is a new right introduced in the GDPR of the data subject, and then now it's reflected in other legislations, other legislation around the world. So this impact was underestimated, and I think it is an achievement of the GDPR if indeed we believe that having rules around how personal data are collected, used, shared in this time and in this day and age is important. Another achievement is the fact that, look, before the GDPR, whenever anyone from my neighbors or family was asking me, what is it that you do? And I was working in data protection, researching data protection. Nobody knew what I'm talking about or cared, to be honest. It was, generally in society, people that were not very curious about new fields of law and law and technology had no idea that these are issues that are real and perhaps they should care about, and did not understand exactly what it is that we are doing and we were talking about here at CPDP already for years. But now, with the GDPR, and frankly, it has been quite a shift after it became applicable in 2018, it's much, much easier to have a conversation with almost anyone here in Europe, but not only, about issues related to protection of personal data, primarily linked to the internet and social media, because this is an interface that everybody interacts with. In the US, it's also very easy to explain what this field is about when I'm speaking about, for example, credit scoring and things like that. So I think these are two achievements of the GDPR. Now, if we're reflecting on whether the practices in the digital economy have shifted, have changed, have fundamentally changed, that's a bit of a different story. I think the practices have shifted. I think the introduction of a data protection officer as someone that needs to be internal to companies that engage in complex processing operations, and someone that has to be there whenever there's a public authority here in Europe that processes personal data. I would say that also drove a lot of change in at least shifting some of the practices. So that's a bit of my optimistic view. I do think that there is a particular obligation in the GDPR that has been underused, and that's the data protection by design and by default obligation, which I think could balance a bit some of the shortcomings that you're pointing out to, Raphaël, on the managerialization of the of compliance and having another tick box. I think that if companies, organizations would be very seriously thinking about designing their systems in a way that not necessarily, leads to tick box compliance, but just designing processes and systems and technology in a way that takes into account all of the principles in data protection law. Now, that would indeed be a wonderful change, and I hope we'll get there. I don't remember the second question, but. Oh.
So my second question, which I'll present to Gabriela, but if others want to churn in, pertains to what I did on my flight, which is read the EDPD decision on Facebook, and on the issues related both to the fine and setting aside the standard clauses. And maybe I could mention three views of a cathedral on what this actually tells us about our discussion. One might be that this issue is an outlier. It's so much vested in politics, so it's not saying anything about what the GDPR actually does or means. A second view might be that the entire GDPR infrastructure led a very large corporation to take a substantial risk, and the risk materialized. And is this really what we want to do? Is this a success story for the GDPR? What are we learning from it moving forward? And maybe a third view is that this all resulted from the fact that the company was cloaked in this situation of great uncertainty, and all the users in Europe suffered from that for all this time, and also that might be a problematic outcome. So these are just three possible avenues to think about it, but there might be others. And Gabriela, maybe if you would want to reflect on that and others.
So my first thought about the meta decisions and for those of you, I don't think anyone that doesn't know what we're talking about, the very recent decision of the Irish Data Protection Commission in the long Schrems saga on international data transfers and the transfer regime from the of personal data from the EU to the US. And the biggest GDPR fine on record, 1.2 billion euros, plus an order to suspend transfers and also an order to seize the unlawful processing operations, so including storage of personal data that has been transferred. This is a decision that was published 2 days ago. Frankly, that's not as much of a GDPR problem itself. It's something that the Court of Justice of the European Union had a very big role in creating, in the way that the Court of Justice interpreted Chapter 5 of the GDPR and what's the level of protection into a third country jurisdiction where personal data from the EU is flowing, and the role of the national security practices and law enforcement access to data, government access to data practices in that jurisdiction plays. That's not necessarily a GDPR problem if you're reading Chapter 5 and how it's structured with adequacy and then the exceptions to adequacy and then the derogations. So I would say it's a Court of Justice of the European Union interpreting the GDPR in a very, very strict manner. It's what's happened there, and particularly in this case and in the whole debate in this particular case, we also have a very visible conflict of constitutional law in between the United States and the European Union. There are so many different and broader dimensions to this case beyond the GDPR itself. And also, let's remember that even the first judgment, the Schrems 1 judgment, which started all of this, was actually given under Directive 95. And then, things evolved. So I'm not necessarily linking this to a failure or a success story of the GDPR, but just thinking about it in the broader context of the CJU and constitutional law and the conflicts we have there between Europe and the United States.
So for me, it's a great example of a lot of waste of good energy for compliance, risk management, and DPA intellectual and other capabilities. Because if there's a serious problem in transfer of data to the United States, probably this is the role of states to deal with their institutions. And if the European Court of Justice thinks this is a problem, I would imagine within what we have in separation of powers and constitutional dialogues, that this would be a role for the executive branch to solve. And as this discussion is going on, the EU and the US, under Japanese leadership in the G7, are discussing global data flows for the global economy, because we're thinking of our world, and the bad people of the world are not in this conversation, they're in other conversations. So for me, it's quite eccentric, I would say, to deploy monetary fines on a company which I have no specific sympathy for under its data protection practices, but because of this initiative, it seems to be something not completely coherent for me. And I think this is another case, thinking post-Schrems, maybe I'll be a bit blunt, of the misuse of risk management concept. The expectation that a company with its limited capabilities will conduct a risk management on a foreign jurisdiction is something quite strange in the concept of where risk management and risk management of technology and of operations has developed. So I would think that this is a role for public policy and its agencies to set what the role is. They can say no transfers to the US, period. But the utilization of the regulatory machinery and risk management and accountability to reach that end is a waste of energy that should have gone to privacy by design. when you think about the limited resources in in-house compliance.
As well, I think limited resources of regulators and other parts of the apparatus that devoted so much attention to this, as opposed to the things we were discussing. Sam.
Yeah, I completely agree with that. And I think the fundamental issue is the conflict between privacy and security. So governments sometimes do need to have access to data in order to track down terrorists or to address serious issues like CSAM on platforms. However, the various governments are not agreed about what should be due process when those requests are made, what should be the safeguards, or what should be the redress mechanisms when citizens' data, wherever they are in the world, is accessed for law enforcement or national security purposes. And because of this lack of political agreement amongst the states, it seems that data protection has been used as a way of Europe trying to influence its powers to get a foreign country to change its national security or law enforcement practices. But just like those issues are enshrined in the EU's treaty as something that is within the sovereign rights of a specific country, the US, or any other country for that matter, has its own sovereign rights to say this is our policy when it comes to dealing with national security or law enforcement. And so to leave it then to companies to say, figure it out, either move all of your servers into Europe or don't offer your services into Europe, or segregate your databases because we as governments cannot sort this out, is imposing quite a big burden on companies. And as a practitioner, I've been working for the last couple of years after the Schrems II decision on multiple international data transfer mechanism projects where we go through the new SCCs, where we think about supplementary measures, and every single project has been this struggle of we're trying our best, but we aren't sure whether we're reaching 100% compliance. So it's been a big frustration for companies.
We have a few more minutes. I have 20 more questions, but I'm wondering if anyone wants to ask from the audience. We have a mic here if people want to queue or ask. And also, before we conclude, I see that Paul de Hert walked in here, and I want to thank him and the rest of the team here in CPDP in bringing the conference together after difficult years. To see here everyone together is really exciting for me. Thank you very much, Paul. I know we didn't plan it, but I'm shaming you here a bit. So if we if we have no more questions, I want maybe a questions to Raphaël moving forward. What are the lessons from the GDPR risk-based approach that perhaps we could apply to other paradigms such as the AI Act and others?
Yeah. Yeah, thanks, Tal. And well, here I would see at least two lessons. And the first lesson maybe has to do with the complexity of the risk management processes, because, well, Amit already talked about it, how difficult it is to come up with a data protection risk management process. And what we see is the AI Act is a very technical regulation, especially in terms of, for instance, how the European Commission should determine what constitutes a high-risk AI system. And in a way, it's way more technical than the GDPR because it focuses a lot of on the harms and the concrete, the concrete violation of fundamental rights. But it remains very unclear on how this would be done. And I think there's a bit of a trap here of becoming too technical and relying upon very technical templates that might not be very practical or workable in practice. So maybe one idea would be to just go back to something more simple, easier taxonomies that might just be more workable, and that, if I understand correctly, companies use in their practice in any case, regardless of the law in the books. So that would be one point. And another point would also, have to do with what I was mentioned before about the issue of trust. And I think, well, if you look, for instance, the proposed AI regulation, of course, it's based on a huge amount of trusts, especially on providers of AI systems who responsible for the quality management system and have a huge role to play in the certification mechanisms. And here I would just say, yeah, be very cautious because, well, this is a nice ideal, but in practice, it does not always translate. So, yeah, that I would definitely point to that.
Are there any questions you want to ask, perhaps, other panel members, Raphaël?
Well, one question I would have is related to that is maybe for Sam, how if you can talk a bit about the translation from these broad requirements in compliance in practice, basically. Yeah.
Thanks very much. For compliance in practice, I think transparency and data protection impact assessments have been a really helpful tool for companies to think about where the data is going and putting it on paper. And once they try to draft a privacy policy, for example, they think, okay, who am I sharing my data with? Or is there any automated decision making that I should be disclosing? And it gives them an opportunity to go back to the business to ask these questions, document and resolve some issues. Things like the DPIA is also useful because there you document, say, for example, the balancing test for legitimate interests, and it gives them an opportunity to think, what are the risks and how can we safeguard it? And so from my practice as a privacy practitioner, I find it very incredibly rewarding when after a DPIA that I've worked on, the client says, okay, we're going to try to put in these safeguards to further pseudonymize the data, or we're going to put in these measures to keep the data more secure, or we're going to limit our retention period, or we'll place a just-in-time notice at this moment in the customer flow so that customers are better aware of the risks of what's happening. And that, I think, is a very practical and very impactful change. And although it's a small thing that not that many people might notice, these little cumulative changes at being more thoughtful, I think, help to raise awareness with the public that use the services and also with the business when they develop similar services as well.
Do you have any questions for panelists?
Yeah, I have a question for Amit. So we have here a very different set of panelists, some in academia, some doing lots of thought leadership, and you with regulatory experience, and me as a practitioner. How can we work together more in the future to try to bridge some of the theoretical and the practical elements to bring this area forward?
So basically, I think that what I've tried to show, what we've tried to see, that there are several disciplines here that we should be aware of and discuss. So when legalizing, and this is what the EU does, it's legalizing a lot of technology regulation, the danger is that it loses track of what the technological or the business community is saying at the same time. And the second risk is that when you transpose risk management concepts to legalese, some of the variables are transposed not completely. So you can talk about harms, you can talk about damages, you can talk about immaterial damages. These are all words we can see over the GDPR, and they are all conceptualizations of what we should look for in the formula. So I think the main lesson from law and technology is what's known as the multi-stakeholder approach, which means that we need to be aware of other languages. And the lawyers, those controlling the legal language, which is, I think, one of the most dominant languages, should also sometimes be more modest in adopting other languages, such as the technical languages and the risk management languages, without being aware of their larger context. And these types of discussions help us there.
So we went 5 minutes overboard, but we started 5 minutes later, so we're overall okay. I want to thank all our panelists. I want to thank the crowd. And this was a very special panel because I'm sure it's the only panel you'll hear in the entire conference that the three letters GPT were not mentioned. So next year, who knows if we'll be here? Maybe we'll send some AI instead of us. Thank you very much. Enjoy the rest of the conference.